So guys, this lawyer has come under fire from Nigerians after granting this interview. In fact, so many people were disappointed in him after saying all he said during this interview. Before I allow you to take a look at the video, I want you to see some of these reactions coming from Nigerians, after they watch this same video. And this one says, this man is a roadside lawyer. It doesn't matter how long a person has built his reputation. It does not warrant them taking laws into their hands. This lawyer does not know what he's saying. And this other person says, this Dele's case is making us know the corrupt lawyers in Nigeria. We are seeing their faces. And this one says, this son of a guy is a disappointment. You are making reference to the UK. In your heart of hearts, are you telling us that the UK would have treated this case this same way Dele Farotimi was treated? And this other person says, my brother, the truth is too bitter to say. If we continue to speak with two mouths, Nigeria will not move forward. Can you imagine a judge who told the CBN to withdraw Rivers local government monthly allocation? What an abuse of judicial power. Do you call it political judgment or corruption? And this other person said, this guy is part of the reason the Nigerian judicial system is in a mess. You are ridiculing a book you have not bothered to read. What a shame. And this one says, this man is a danger to common sense society and civil society. This was too sad to watch. He lacks ethics and moral values. Most of all, he doesn't care about constitutional process. And this one says, this man is part of the book itself about the criminals in the judicial system. Dele Farotimi is already vindicated and must be set free. Black African unity. So guys, I'm going to let you watch this video for yourself to know why Nigerians are crucifying this man after granting this interview. He talked about so many things, I'm just going to let you watch this video for yourself, just for you to know that, like somebody said, that we are now beginning to know the lawyers who are standing with Nigerians and those who are working against Nigerians. So guys, take your time, relax and watch this video and let me know your thoughts in the comment section below. Take a look.
More about the alleged defamation case of Lagos-based lawyer Dele Farotimi against senior advocates of Nigeria, Chief Afe Babalola, and the justice system in Nigeria. We have the views of senior advocates of Nigeria, Yemi Kandi Johnson. Before bail was granted, I sat down with senior advocates of Nigeria, Yemi Kandi Johnson, to get his views on why there appears to be no uniformity in the laws on criminalizing defamation and what obtains in some other developed jurisdictions.
Well, every state is entitled to make law as it chooses. You see, all law is about preserving safety, security, progress of an environment. I've heard this said so many occasions that criminalizing defamation is somehow intended to have a chilling factor on freedom of expression. It is fundamental that we have freedom of expression, but it is also fundamental that there is a limit to that freedom of expression. That freedom consists in limiting expression which may be damaging to individuals, to the reputation, to the sanctity, to the safety of the state. These are things which the states and lawmakers have a legitimate right to protect. Now, the idea that defamation is not to be criminalized is utterly preposterous. Every society must determine what type of expression can endanger it. In France, from where I've just come, it is still a crime, defamation. Under the penal code, if you made accusations of a woman as regarding her chastity, that was regarded as something that could lead to dramatic breakdown of law and order. It is criminalized. In the UK, under the common law until 2010, defamation was still a criminal offense. So there's nothing remarkable about defamation being a criminal offense. What is important is not this fancy argument, which is resolved, and I think will be resolved in those courts by determining whether it's on the statute book in that state or not. It's a simple enough question, but there's no fundamental issue of principle which makes it unacceptable for defamation to be criminalized. Personal reputation is something that everybody who has it is entitled to protect. In many respects, it's more important, as one holy book says, than diamonds and jewels. Certainly, if somebody defamed me, I would be very concerned to defend myself by whatever process the law made available for me to do so. So that is one aspect. The second aspect I think you asked about is as to the whole process and system by which you talk about arrest, etc. Well, you know, the question of whether an arrest is carried out in an orderly or lawful manner is a matter to be determined in that circumstance. As a general matter, if an offense is committed in one state and a complaint has been made, a person that is found anywhere in Nigeria can be arrested and brought before a judge in that particular state. There's nothing new about that. This is simple law. Anybody who read Patrick and Jovens of the States, which I think is a 1972 case, knows that this is something that can be done, that the courts have held up to the Supreme Court, that if a person is brought before a court, it doesn't really matter how they got there as far as the jurisdiction and power of the court before whom the person is brought. As to whether a person should be arrested violently or brutalized, I think that is clearly unacceptable. This is a human rights matter, not a matter that relates to the defamation or the process that is initiated in that case. Certainly, if excessive force was used to arrest any person, I would find that to be objectionable and something that is worthy of criticism. I would also find it difficult to see a person who has been detained, treated with inhumanity or not given the basic rights. You know, the value and the protection of our system of justice is not just in what it does, it's in what people say and what people think about it. I think that if any aspect of legal process is abused, it is damaging to the credibility, the integrity, and the functioning of the system of justice. And that is something that judges and anybody else who's operating that system should bear in mind.
But what will be your response to those who say that Chief Afe Babalola should have filed a civil suit rather than a criminal suit?
My response would be that when such a person is defamed, they should decide how they will defend their reputation. I will not accept for anybody to tell me what legal process I should use to defend my own reputation. And it's all right for roadside commentators to give a variety of views as to how an individual should protect himself. If my reputation was attacked, I would reserve the right and exercise the judgment, which is personal, as to what process which is available to me I would use to protect it. I don't think it's anybody's business to tell Chief Afe Babalola how he should protect a reputation that he has built and nurtured over decades. Some of the people commenting on this reputation were not born when he was in the trenches.
Have you read the book?
I've seen excerpts. I haven't read the book. I don't have $17.23 to donate, but I've seen excerpts in various social media platforms, which everybody is going to be involved in one way or the other. And the reason why you ask me, I guess, is to what I think about it.
Yes.
What I've read of it is scurrilous and scandalous. I think that truth is something which the entire public has an interest in establishing. If there are bad eggs in the judiciary, if the judiciary is corrupt, if any individual, no matter how large or how famous they are, is corrupt, and this can be established, they ought to be exposed, they ought to be shunned, avoided, and they ought to face disgrace and other penalties. But I think it is entirely irresponsible for anybody, more so a lawyer, to publish in language so, how should I put it, that is so extreme and so abusive. It lacks judgment and consideration. And while the question of whether those allegations are true or not is something which is for a proper tribunal, I think it is important when a person makes such allegations, first that they exercise judgment and discretion. And a lawyer should know that what you can't prove cannot be said. I asked some friends of mine recently who have taken various views on this matter. Can anybody in this room name a corrupt judge? Oh, someone said, well, I know some, but I won't. Some said, I don't want to get into trouble. Well, the fact is that preserving rights and liberty costs. Someone said, if you want to fight for liberty and justice, don't wear your best trousers, because you're going to fall on the ground. But then, if you have conviction, it's a good thing. But the conviction requires facts. You need to be able to know what is said. If I had it on authority and I was clear that a judge was corrupt, and anybody who knows me would know that I would name the person to their face. I think Chief Afeba Balala knows that if I felt something about him, about his conduct, I would say it to his face. But I wouldn't make a publication in wild, scurrilous, and irresponsible language, which is going to be circulated to the world, and not expect to be tested as to its veracity.
I think a lot of people have issues with the way Farotimi is being treated by law enforcement agencies. Leave the man to prove his case. Why lock him up? Why put him in handcuffs?
Well, I was shocked at the image of a legal practitioner being held in handcuffs. Not because a legal practitioner, but because legal practitioner is someone who we assume has respect and is going to behave himself, even if the person's utterances belie that assumption. But this offense, which is charged, would be a misdemeanor, maybe 2 years imprisonment. Okay, he's not likely to be violent. I think that the impression I got from seeing that picture was that the intention was to humiliate him, which is entirely inappropriate, entirely unnecessary, and counterproductive. The judicial system depends on its reputation. The law must be vindicated. People must go through the process. But the effectiveness of the legal profession and the effectiveness of the justice system depends on people seeing that it acts in one way for everybody. Nobody can be above the law, and nobody can be below the law. So Dele Farotimi is not below the law, and he's not above the law. Chief Afeba Balala is not above the law, but he's not below the law either. The law should be available for everybody. And I think that if it appears that the discretions being made about exercising prosecutorial or criminal jurisdiction are personalized, then it is damaging to the reputation of the justice system across the board.
One of the things Farotimi said in his book was that Chief Afeba Balala corrupted the Supreme Court to procure fraudulent judgments for his clients. As a senior legal practitioner who appears regularly before this court, would you say that our Supreme Court is corrupt?
The short answer would be no. I certainly take exception to some of the decisions that that have come from the courts or from any judge. But I sit in judgment myself. Many aspects of judgment are matters of impression and of judgment. This is why you give judgment to individuals. Some people say the UK Supreme Court is corrupt. Articles in the Atlantic last month say the United States Supreme Court is corrupt. Why? Because in particular cases where people disagree with them, they have a different judgment as to what should and should not have been done. But the judgment is not ours. I think that anybody who has risen in our profession should have the understanding that the integrity of the structures of our justice system are so important that our first duty must be to protect them. We must protect them against people who will attack them from outside, and we must protect them against those who will attack them from inside. A corrupt judge, a judge who gives inconsistent and unreasonable, patently irrational decisions, is a threat from inside to the system of justice, and such a person should be resisted as well. But that being said, you cannot, having regard to your duty to preserve the system of justice, your responsibility to something that has nurtured you, and something which is essential to the safety and progress and development of our society, you cannot burn it down just on your whim, on your impression, on your prejudice. You have to have facts, because without facts, you are going to vandalize a system which is fundamental and which we all rely upon. With facts, you can surgically extract those who are threatening the system, and you can remove them. So again, to answer your question quite simply, I do not believe the Supreme Court is corrupt. I have disagreed with many decisions they've made, but I believe that this is a judgment that they have been given the power to exercise, and we must accept that judgment.
When people look at decisions from our courts, and I'm talking about all the courts now, and we see inconsistent and conflicting judgments from our courts, doesn't that make the case for those who say that our courts are corrupt?
Sure, there are inconsistent decisions. I think that is a problem of incompetence. It's a failure of administration. There's no reason why a high court should give it. Much of the law is very simple and straightforward. There's no reason why there should be inconsistency in decisions on simple and straightforward issues. Where discretion is allowed complete free reign without the regulation by law and by principle and by precedent, then you have a problem, because then individuals may behave in any way, whether provoked by corruption or not. They can give decisions which people will find difficult. There must be consistency in the law. There must be consistency in judicial decisions and judicial decision-making. You see, I think that you will find that most of these inconsistencies you refer to are in political and politically sensitive cases. This is actually the truth. And I think that it is difficult to avoid the conclusion that many of the judges in those cases are exercising political judgment rather than legal judgment. That is my view. And this is dangerous. And the task of the higher courts is to guarantee certainty in the law and consistency across decisions. That is their job. That's what the Chief Justice of Nigeria should be thinking about.
I hear what you say about the need for decisions of our courts to be certain, but what else do you think that the courts, and especially the CJN, can do to engender trust in our courts and the justice system, especially in terms of reforms?
Our Supreme Court can reduce the time that is wasted in appeals, which allows people to think that the law can be dragged on endlessly. This is part of the problem of defamation. People think that if I go to a defamation court, I'm going to be in court for 20 years, nothing's going to happen. Better to resort to the criminal law. Because people don't have the confidence that judges can decide cases efficiently. And they can't decide cases efficiently and quickly because their procedure is abused, and they allow lawyers, especially senior lawyers, to abuse the process and procedures. The procedure should apply the same to everybody. Efficiently. This is why justice is portrayed to be blind. I don't care who you are. This is the process and the procedure. So that is something that can be done. There are too many cases in the Supreme Court. The Supreme Court grants leave to too many appeals to be heard. Too many interlocutory appeals should not, as a matter of policy, the Supreme Court should not hear any interlocutory appeals. It is important that cases that you can approach the courts in a structured and efficient way. It's important that the courts use their time to decide cases in the quickest way that is possible, because no single case is more important than the administration of justice across the board. That's something they ought to bear in mind. One of the greatest impediments to the progress of justice in our courts is that lawyers are given too much leeway to be dilatory, to be inefficient and incompetent. If you stand up in court and call yourself a senior advocate of Nigeria, you must be prepared. I was talking with a friend of mine who's a judge in Hong Kong, and she was complaining about some of the cases that they do, and some of the lawyers are very unprepared. And I said to her, well, sometimes with our senior lawyers, they don't come to court prepared. She said that would never happen. She's talking about junior lawyers. So you wear a rank, you expect to prove it when you stand up in court, and you must be prepared. But in our environment, people tend to be sentimental and tend to assume that there must be a way. Courts need to make it clear to people that there is no way. The law is the law, even if it's hard.
It's no more news that the Chief Magistrate Court in Ado-Ekiti, Ekiti State has granted Lagos-based legal practitioner Dele Farotimi bail in the sum of 30 million naira, 16 days after detaining him for alleged criminal defamation of Chief Afe Babalola. As part of the bail conditions, Chief Magistrate Abayomi Adeosun ordered Farotimi to provide 2 sureties who are responsible citizens of the country, and one of them must own property in Ado-Ekiti. The court also barred Farotimi from granting media interviews or making comments on the case pending the determination of the substantive suit in court. Farotimi was also ordered to submit his international passport, but following the submission by his counsel that the passport was already submitted at the Federal High Court at Ado-Ekiti as part of the bail conditions granted by that court, where he is also facing trial, the magistrate ruled that the defense team should provide a document from the registrar of the court confirming the receipt of the passport. Citing judicial precedents, Magistrate Adeosun also ruled that senior advocates are not permitted to appear at the magistrate court. He adjourned further proceedings in the case till February 13, 2025. Farotimi's lawyers, while speaking to journalists, said they would work towards perfecting the bail conditions in record time so the defendants can be free from custody. But
the latest news around the contestation between Chief Afe Babalola SAN and Mr. Dele Farotimi and all of the drama that we have seen. Joining me to have this conversation is a leading voice that has been calling for judicial reforms in our country, a law professor. I'd like to welcome back to Inside Sources, Professor Odinkalu. My brother.
Compliments of the season, sir.
Exactly, same to you. It's good to have you again right here in the studio.
Thank you for having me.
Thank you for coming.
Thank you.
So, Prof, please help us to, within the larger context of, what has happened, some of the fallouts that we have seen in the judiciary, quite a bit of concern. I remember the particular instance, I think it was 2020, when Justice Amina Ogi, made a very strong ruling against Chief Afe Babalola and one other senior advocate who had brought a case, that Supreme Court had decided in this Payasa David Lance matter. And Justice Amina Ogi, now retired, gave a very stinging comment in her ruling to say that, that matter that was brought back for the Supreme Court to review itself was not only vexatious, she even said that it is, in her view, the desecration of the Temple of Justice. And she went ahead to impose a 30 million naira, personal fine.
Punitive costs.
Punitive costs against Chief Afe and the other SA. Now, so that tells us that there are issues around when the Supreme Court can review itself. Can you just educate us around that? Because it seems, in my own reading, I'm not a lawyer, but I think, this is must appeal to common sense.
I'm not sure there are any lawyers in Nigeria left, by the way. That's another matter.
Because it seems to me that that's one of the causes of the matter in this Dele Farotimi contestation, because he is arguing that the review that happened on the matter of the land case in Osapa, London, in Lekki, is about the improper review of Supreme Court ruling in the case. So I wanted our audience to have a fair understanding of what is not and what is.
Oh, thanks a lot. I like to preface everything I say about law in Nigeria with two health warnings. First is, I'm not quite sure I can claim to be a lawyer anymore. Secondly, the reason for the first is, many of the decisions that happen these days, I cannot understand them. The words, each word I read, I can understand. When I piece them together, the logic just breaks apart in many of the decisions, admittedly not all. Yeah. And so I like to be careful about making any claims about Nigerian law, or indeed putting forward any credentials in law in Nigeria at the moment. There were fairly well-established rules at the time my generation made claims to entering the profession. There were fairly well-established rules as to how the apex court could change its decision, and indeed alter a principle of law that was settled at that level. First of all, in terms of discrete decisions, there's something called the slip rule. So if there's a typographical error or there's a mistake, a manifest error on the face of the judgment, right, a court can alter it without altering the underlying decision. Right. Because after all, judges are human beings, and sometimes mistakes can happen, and some of those mistakes are not that fundamental. However, if and to do that, however, you've got to make sure all the parties are present, so that it's open what's happening. And so there was a particular case in Lagos, in which one of the most credible judges, probably ever to pass through the High Court of Lagos at the time, Justice A.L.A.L. Balogun, encountered something similar in his decision making, but communicated only with one of the sides and not all the sides in the case. And the Supreme Court took a very dim view of that conduct. If he had not been Justice A.L.A.L. Balogun, known for his integrity, his personal integrity as a judge and as a person, I think for most other judges, he would have probably lost his job, for instance. But nobody, I had the privilege of doing my court attachment in law school, actually, with Justice Balogun, and he was an extraordinarily honest, decent man. That was what saved his position in that time. But the Supreme Court can, of course, overrule itself. And when it wants to overrule itself, when the Supreme Court sets out to overrule an existing principle of law, it convenes a full panel of 7. Now, in this particular case, I think what the issue, from what I understand, I may well be wrong in my reading of the facts, there was an original decision relating to 10 hectares of land or something. And subsequently, on an application for a review, that then evolved to 250 or something. Yes. So a fairly significant alteration of the final of the interest, the underlying interest in the case. Now, I have not read the record of proceedings, so I'm not going to hold forth on whether or not there was justification for that. But of course, if you're having a change of that magnitude in the underlying subject matter, right, people may well have good reasons to question whether that is within the framework of the slip rule. or whether it is within the framework of an apex court, or indeed any court at all for that matter, to alter or review itself with a view to reaching that kind of outcome. I do think there could be legitimate disputes as to that, and I can see how such disputes could ultimately devolve to questions about the credibility of the decision making. As I said, I've not read the record of proceedings, so I don't want to hold forth on that particular issue, but I could quite easily see that people may begin to think there are smell test issues involved in that.
Interesting. So in your own view, there have been quite a few commentary around how Dele Farotimi was arrested, how they came from Ekiti to Lagos and put him through a magistrate court that refused in its own ruling to deny bail the first time, asking that, look, go and bring the formal application. Days after, brought the formal application, and then they said that, okay, you know what, I'm going to take my time to decide. What do you think is happening in this matter? In your own view, what's your take?
Well, because of the way you framed the question, let me declare my interest. I'm one of those people who have who's done a commentary on this.
Okay.
So I don't want to come here and kind of pretend I'm innocent on this particular matter. But I think people need to know a few things about the underlying principles of law. Number one is that a magistrate's court is known as a court of summary jurisdiction.
Can you explain that to Nigeria?
Now, a high court, a magistrate's court is a court of summary jurisdiction, and a high court is a superior court of record. That means in the high courts and above, customary court of appeal, Sharia court of appeal, federal high court, national industrial court, courts of coordinate jurisdiction to the high court and above, everything should be on record. And so a high court, if these charges were before the high court will be well within its rights to say, bring an application in writing, because those are superior courts of record. Of course, every court is of record, but not every court is a court of summary jurisdiction.
Okay.
So a magistrate asking for an application.
So a court of summary jurisdiction means that when matters come, you deal with it summarily. All right.
Exactly.
So I understand. Yeah.
So a magistrate asking you to bring an application in writing for bail on a crime or a charge in which the maximum penalty is 2 years, either has not gone to school properly or has a mission to fulfill, with all due respect. All right? Now, there are three categories of crimes known to Nigerian law. Simple offenses. Simple offenses are crimes punishable with not more than 6 months in jail.
Okay.
And so you can dispose of those with fines and easily. Now, then you have misdemeanors. Misdemeanors are punishable with not more than 2 years in prison.
Okay.
Those are also not exactly the most serious of crimes. Then, number three are felonies. Felonies fall into the category of serious crimes. They are punishable with more than 3 years in jail. Right? Now, the maximum penalty, let's leave all the other jurisdictional issues. So let's assume everything is right in this case. The maximum penalty for this particular charge of criminal defamation, the charge is brought against Dele Farotimi, 2 years. Yes?
It's not a felony.
It's not a felony under any circumstance. Now, there is therefore really no reason. There's actually no basis. That's no basis for this procedure of, okay, bring a formal application. And then, instead of exercise, and secondly, that the suspect in this situation is entitled to bail as of right, because there is a presumption of innocence. But part of that is also a policy reason. In our prisons in Nigeria, over 75% of the people in metropolitan prisons are awaiting trial. Okay? That means that the prisons are not holding the kinds of people they've been built for, which will be convicts.
Yeah.
And therefore, we're spending assets and lean public resources on the wrong kind of people. And the average duration of pretrial detention is over 3 years.
In Nigeria?
In Nigeria, as we speak.
Wow.
That would be the average duration for a felony. And many of those people will never complete trial. And therefore, there are actually compelling policy reasons why the courts have to make sure that wherever the crime is bailable, they exercise the powers discretion in relation to bail.
As it means perhaps also even decongest.
Precisely. Okay, so there is a presumption of innocence. The crime is modest at the very best, allowing for every other thing. And there are compelling policy reasons why the magistrate, as I said, any magistrate who will tell you to bring a written application for bail in this kind of case either needs to go back to school or has a mission to fulfill. On that, I'm willing to go on record. It is such a travesty of due process that it has to be said by somebody. But there is something else. You see, Nigeria has 37 or 38 legal systems. Every state is one legal system. The Federal Capital Territory is a separate legal system, and then there is a federal legal system. That's 38. And when you issue a warrant in one state for execution in another state, number one, the crime has to be a crime in the state in respect of which the warrant is issued. Okay. That's number one. Number two, when you take it to the state in which it is to be executed, it has to be, a magistrate in that state has to countersign and validate that before execution. We don't know whether there was any validation of the
warrant from Ekiti.
But what is very clear...
So sorry, you mean that the warrant that came from Ekiti had to be countersigned in Lagos?
By a magistrate or justice of the peace.
Right. Mm-hmm.
Okay? Now, that we're unclear about, and I'm not going to speculate about that. But when you are talking about issuing a warrant in Ekiti State for the crime of criminal defamation, there is no crime of criminal defamation in Ekiti in 2024.
Well, I read that, and I'm sorry to interrupt. I read that in your piece.
Yes.
So, Femfran of Senior Advocate of Nigeria says that there are 2 states that have decriminalized.
There are 3. Ekiti is the third.
I see. Okay.
Wale Fakunda, Senior Advocate of Nigeria, was the Attorney General when that happened. Kai Defayemi was the governor who signed it into law in 2021. You can verify from them.
Interesting, because, and I'm happy to hear.
Edo State has decriminalized criminal defamation. Lagos State has criminalized criminal defamation.
So Ekiti
State decriminalized criminal defamation in 2021.
Yeah, because everybody seems to respect Fakunda, and when I heard about it, I was thinking that Fakunda was Attorney General for quite a long time.
Wale Fakunda was the Attorney General of Ekiti State who was responsible for shepherding the.
So he actually also did that in Ekiti State.
Precisely.
So how is it then possible for Chief Afe Babalola to write a petition and the police acted and they are now charged? Because they've actually charged Mr. Farotimi.
Only the police can explain that, and the CP Legal is a Senior Advocate of Nigeria, right? Now, so nobody seriously contests that criminal defamation. I'm honestly not sure that they knew that this was the case, that criminal defamation was not a crime in Ekiti State. But the argument now then evolves. Now that it has become clear that criminal defamation is not a crime in Ekiti State, the argument or their position has evolved or mutated. So they're saying, well, they are not charging him under the criminal law of Ekiti State 2021. They're charging him under the Criminal Code Act of Nigeria. Now, that does not exist as a source of crimes for the states.
Can you explain that?
And I will explain that. The Criminal Code Act was enacted as a colonial ordinance in 1916.
Okay.
At that time, we had 3 territories in Nigeria.
Right.
Protectorate of Northern Nigeria, Protectorate of Southern Nigeria, and Colony of Lagos.
Right.
Right? The Criminal Code Act applied to the South, the Southern Protectorate, and the colony. In 1951, we changed from that structure of North-South colony to a federation. And then, following the work of Governor General Bodiland, we split up the South into 2 different regions. So we now had 4 territories: East, West, Lagos colony, and Northern region. The North, of course, had the Penal Code. And the Criminal Code Act then evolved into the ordinances for the regions.
Okay.
Yes? Now, when the states were created, when Midwest was created by the Federal in 1963, it became legacy law for Midwest. And progressively, it became criminal law for the various states.
So what became criminal law?
The Criminal Code Act
then
got adapted by the various states as micro-territorialization, the creation of states evolved. It then evolved with them and became the criminal law for the various states of Nigeria.
Okay.
The federal government does not have powers. When you look at the exclusive legislative list, or indeed the concurrent legislative list, the federal government does not have powers over general criminal law for the states.
Interesting.
That means that the Criminal Code Act does not create any crimes for the states. It lapsed as a piece of source of criminal law for the states.
When did it lapse? Based on this analysis now.
It lapsed not later than 1967.
Okay.
The only territory in Nigeria in respect of which it is arguable that is applicable is Abuja, because it's a federal territory.
Right.
And I say arguable. I could dispose of that, but it's not necessary for this particular purpose. But as a source of criminal law, it does not exist in Ekiti.
Interesting.
And Chief Afe Babalola himself was involved in a 2021 case in which the Supreme Court decided a similar principle. The case of CIL against Ekiti.
So what's CIL?
It's the name of a company.
Okay.
Yes? But this was a civil case. And in that case, Ekiti State, as in this particular case, had legislated out of existence a piece of legislation called the Public Officers Protection Act, which provided for certain procedural measures in terms of suing public officers. Right? Ekiti State legislated out of existence. And the argument was that since public officers were being sued here, the federal act, the Public Officers Protection Act, should be imported into Ekiti State to provide for what was not provided, what had been repealed by Ekiti State's laws.
Right.
The Supreme Court said no.
You can't do that.
That you cannot do that through the back door. Okay, you cannot back-channel legislation like that. If a state, as a federating entity, has elected to repeal a piece of legislation, you cannot force it through the back door to nevertheless be bound by a law that the state has legislated into existence. So the principle of law here is very clear. Unless, of course, we're trying to manufacture something unknown to law, in which case we should say so.
It's interesting, this journey that you're taking us to, because I'm sitting down here trying to make a sense of the fact, as you have articulated, that criminal defamation is actually no longer in the books. And even Chibafe's petition referenced that, police action. And it's quite, it's very worrying, for some of us to have to even imagine that in a country where we pride ourselves as free citizens, a country that we are no longer enslaved subjects, we're no longer colonial subjects, that the very idea of retaining that kind of a law, which had a colonial mandate, they brought the law just so they can harass our nationalities and stuff like that. But to now find out that, in fact, Ekiti State in particular has actually ended it's no longer extant.
That is what the situation is.
So guys, you have seen it for yourself. I posted a video about where Chidi Odinkalu also commented, on this case. And most of us watched that video and loved it. Loved the psychological aspect of it. Loved, the way he spoke, the sense it makes and all that. I mean, so many people applauded Mr. Odinkalu for really dissecting it the way he did in that video. And it was sad to see this one is just like an opposite of what Mr. Odinkalu was saying. And one keeps wondering, and as if these lawyers, they don't even know that the judiciary is this corrupt, and they are not raising alarm. The only person who has tried to raise alarm is the retired judge, if we can remember, from the north, who when he was about leaving, he gave his, they call it valedictory speech or something like that, and he exposed some of the things that he's saying he doesn't really have time to dive into. But the question is, why was he saying that at the time he was already leaving? Why didn't he say it at the time he was serving, so that we can know if there are things that can be done? Now, Mr. Dele Farotimi is the only one who is now raising the alarm and blowing the trumpet, calling attention to what is happening in the judiciary. And some of the lawyers are still siding, those that believe are the powers that be, that shouldn't be dented, shouldn't be talked about. So guys, I don't know what you make of this video. In the comment section below, drop your thoughts and let me know. Please don't forget to subscribe to the channel, turn on the notification bell. Please give this video a like so that YouTube can recommend it to others, and drop your thoughts in the comment section below. Thank you.